Friends, so this data protection, the concept, so is having its own constitutional validity in India. So since age-old times, in one name or the other name. So, and when the protection is there, so the people who are making errors on that area is common. Here, constitutionally, these things which have been accepted and having its validity in the name of official secrets or disclosing confidentiality or whatever may be the components. So when these technological developments have been came into force, so by that time, the general data protection regulation is having its most importance, and it is getting the change in data privacy regulation since 20 years. Now, India has its own version of data protection regulation, and it is having its own key aspects for getting deliberation. So, the key aspects means we can say that it is the principles relating to personal data processing and the categories of personal data and rights of so data subjects, and also obligations and controlling of its processes. So all these things which has to be researchly or as per research, so we can say that data protection by design. So like that, and the information security as well. So and at the same time, a good governance towards data protection is very, very essential. For that purpose, we can say that in our country, so the personal data protection bill, which has been introduced in 2019 December, and it has been introduced in Lok Sabha, and whether subject to correction, it has not yet been made as an act here. So, of course, after 19, we are facing these pandemic situations. Why all these laws? One side is when we are talking about rights, and at the same time, so the duties also will come. Similarly, when we are making protections, the crimes will increase. So when this data protection, so we are trying to make confidentialities, there are. So the other component like whistleblowers, so official secrets, which has not been maintaining by some of the employees in companies, even in some families as well, they are not making appropriately, so maintaining secrecy. In such and such circumstances, it is the need of the day to discuss this data protection, and at the same time, after this COVID, that means during the period of this COVID, we are using much more technology for the purpose of communications. When this technology is using, that may be the individual people or any organization, companies or the government through technology. When the data one side is going on, the increase of cyber crimes, so which has been so making more and more today's, if you see, and also the other side, social media and the other technological aspects which has been. Now, though the Information Technology Act, which has so is a new component and it has not been completed years together, it is a new act. So the act also having non-coverage of some of the areas today's cyber crimes or internal so security lapses, these things are happening. Under these circumstances, when so Advocate Babu Ram Ariel sir, who has given consent to give his contribution towards this and addressing to our gathering for them. So I congratulate and I appreciate for celebration of this international webinar. So I think that the program will get a great success with the So contribution of Advocate Ariel sir. So I wish all the success. I declare that this international webinar has inaugurated. Thank you very much to all the students, faculty, and management and principal as well of Dr. Babasaheb Ambedkar Law College. Thank you very much.
Thank you, Honorable Reddy sir. That was very kind of you to give us your time from your precious time. I understand that you have an urgent meeting. Thank you, sir. We have our speaker who has joined us from Nepal all the way. Advocate Baburamji Ariel. Ma hujurlai swagat garchu. Swagat che.
Dhanyavad. Thank you very much.
Thank you, sir, for joining us. I call upon Professor DB Patil sir to introduce our guest. Professor DB Patil sir.
Excuse me, sir, you are muted now.
Am I audible? Good morning to all.
Yes, sir, now.
All respected dignitaries in this international webinar. Today I am very happy to introduce my dear classmate and very renowned eminent personality, Mr. Baburamji Arial from Kathmandu, Nepal. Mr. Baburamji Arial has completed his LLM from Pune University. Then he went to Oxford Annesburg Summer Institute, Oxford, UK, and US Telecommunication Training Institute in Washington, DC, where he trained on media policy, cyber security, and ICT policies. Then Baburamji Arial is the founder and CEO Delta Law Firm at Kathmandu, Nepal. Sir has over 15 years experience on telecommunication, including internet and cyber law and media technology, intellectual property, international business, foreign investment, and other commercial laws. Sir is a part-time professor in cyber law and intellectual property law at Tribhuvan University, Nepal. Advocate Baburamji Arial has significant intervention at national and international level research on law and policy. He led the consulting service of drafting in Information Communication Technology Bill 2018 and coordinated the consultation meeting of stakeholders on Cyber Crime Bill 2018. Dr. Advocate Baburamji Arial is also a vice chair of multi-stakeholder steering group of Asia Pacific Regional Internet Governance Forum and Nepal Internet Governance Forum. He has participated and conducted various internet governance related activities, national as well as international level, includes IGF, Asia Pacific Internet Governance Forum, and he has also participated in Internet Governance Forum at the international level. His major work is in the field of cyber law, cyber crime, e-commerce, international law, internet law, international contract, intellectual property rights, and telecommunication law. Advocate Baburamji Arial has huge experience to work at the international level. He has also a multi-dynamic personality in the field of cyber security and internet security. With this brief introduction of dear Dr. Advocate Baburamji Aryan, I stop here and I feel very happy to introduce Dr. Advocate Baburamji Aryan, and thank you for giving opportunity to me. Over to Sheikh Madam.
Thank you, sir, for that brief and nice introduction of our guest. Advocate Baburamji Aryal, you will be doctorate very soon. So I wish him a good luck for that. And I call upon you, I welcome you, sir, to give your speech. Over to you, Advocate Baburam Aryal.
Thank you very much. It's indeed this discussion. Professor Daga Patil, who is a very good friend of mine when I was in Pune University, and I have very good memories from Pune University and Maharashtrian culture, various foods and other kind of cultures, and I love sharing my experience that enriched from Pune or Maharashtra itself. The beginning of my career of this ICT industry starts from Pune itself. So it's my pride to join this discussion with Maharashtrian, my friends. I'd like to thank chief guest of this event, chairperson of this event, and all the faculty and participants of this program, international webinar on data protection in South Asia, and basically post-COVID era. Can I share my slides here? If you allow me as course, then I can share my slide. So
yes, sir, you can.
I was in Pune in 2004-2006 and had good experience in hostel, and Professor Daga and all other friends were there, and we enjoyed a lot Maharashtrian food culture, and it was part of life since then. Then I also started working in Pune itself in the area of cyber law. So my basic goes to Maharashtra and India in this legal practice and legal consulting practice. So it's my pleasure to get those knowledge and share this knowledge to you dignitaries and participants. So I'm trying to share my slide. Yeah, I can share now. Is it okay? My slides are okay in frame?
Yes, it is visible, sir.
Yeah, thank you. Yes, sir. So data protection, privacy are very significant aspects of human lives. And in India, right to life, basically enshrined in Article 21 of Indian Constitution, is significant background for the protection of privacy and data protection in the region. And this provision extended in other new constitution in the region, especially in Nepalese context. Now we have this as a separate right to privacy as a constitutional guarantee in our constitution. So Indian constitution has a very rich background on right to privacy, but still dedicated data protection law is due from Indian perspective as well. In this context, today I'll share conceptual framework of privacy and data protection. What is privacy and what is data protection as a principle? And I also give a little bit reference of major data protection or privacy laws in South Asia, and some of judicial approach in South Asia. Basically, I'll refer a couple of cases from Indian perspective and Nepalese perspective as well. And I'll talk about health-related data and production in post-COVID-19 era, and we'll sum up this today's sharing session on data protection. So, what is privacy? What is data protection? This is very important thing, and privacy is part of right to life, as I mentioned from the Indian Constitution, Article 21. And right to privacy is basically is attached autonomy or anatomy of an individual that is related with individual's information, and that is protected under the either right to life or it's as a fundamental rights in the Constitution. And privacy enables to protect an individual himself or herself, and also this is that kind of rights which is very peculiar to individual and inalienable part of individual, because it is related with the body and the fame of an individual. So it's very important aspect of fundamental rights given by various constitutional or international institutions. Basically, when we talk about privacy and data protection, and we have to go through the international instrument that ensures our constitutional and fundamental rights of privacy. And this is basically when we talk about international instruments, and obviously it comes United Nations Declaration of Human Rights, UDHR, in which was agreed in 1948 after the Second World War. Article 12 of this UDHR specifically provides the right of privacy of an individual. And the next very important instrument is obviously International Covenant on Civil and Political Rights, which was agreed on in 1966. And Article 17 of this International Covenant on Civil and Political Rights of 1966 provides the protection of privacy of an individual. It says no one shall be subjected to arbitrary or unlawful interference of an individual's privacy. So this is very important legislation, and when we go to the court and we repeatedly refer these two international instruments, basically in Nepalese contracts, we have one legislation that says that if any provision of rights related provisions or matters is contradictory with the international instruments or promised by the government, for example, United Nations instruments or international treaties, in that case, international treaties are in force. So these legislations are very important legislation that gives the basic fundamentals of right to privacy in our practice. So other than these two major instruments, we can also refer other some of instruments that gives significant protection of right to privacy. That could be as we can refer that Article 14 of United Nations Convention on Migrant Workers, also right of the child. We can say this CRC is very important while protecting child's privacy in Article 16. Similarly, African Charter on Rights and Welfare of Child also relevant. Other American Convention on Human Rights is also very important instrument for that jurisdiction. So there are other instruments as well that protects privacy of an individual. So we talked about privacy, and now it's data protection. Data protection is comparatively a new concept when digital platforms were very common. When we enter into cyberspace rather than physical space, then we started putting our lots of information, individual information in the database and in digital format. In that way, when it developed a big chunk of our information in cyberspace, the concept of data protection emerged. And basically, the concept of data protection is the part of privacy protection. And privacy is basically an individual's rights related with his body or her body, or fame or health related matters. And the data protection is extension of these informations in the set of database. And when we store in that, then that is also important aspect, and we need to protect that as well. So what is the scope of data protection? Basically, in data protection, we talk about personal data or personally identified data. In this context, personal data means data of living individual. But not only living individuals data is protected, but deceased individuals data is also protected through his or her legal hair. So it's very important part of data protection is that personal data, which is identifiable to identify that person's personality, background, nationality, various issues are there. I'll talk this in next context. And what major issues are the part of personal data, or what are the scope of personal data? Basically, racial or ethnic origin of an individual is part of personal data. Political opinions, which party I belong to, whether I belong to BJP, whether I belong to Congress or any regional party in India or in Nepal or in any jurisdiction. My political opinions are also protected on the personal data. Another important part is religious or philosophical beliefs. What religious belief is, what religion I propagate, what philosophical beliefs I practice. This is also my very personal data and protected under the data protection principles. And membership of trade union, which trade union I belong to, is also part of personal data and protected under the principle. And my physical and mental health or condition, this is very significant when this COVID-19 pandemic erupted around the world, and the contact tracing, location of an individual, and information about the COVID-19 positive test. These are the very significant issues were in challenge or in discussion during this post-COVID-19 era. We'll discuss more on that later on. And then sexual life or sexual orientation, whether I'm gay, lesbian, or transgender. These are my very personal part, and these are the protected personal data under the principle. And also proven or illicit offenses, including legal proceedings and their outcomes. This is also part of our individual personal data. There is some discourse on right to be forgotten in Europe, and even search engine are prohibited to some extent in some information that what past behavior was mine, what legislative issues were there, what were the court judgment were there about me or my criminal engagement. These are also